invited by Nigerian companies to come and turn around. There are 7 companies. He went there and turned around those companies and make them profitable. This is not what is very interesting. More interesting is that when he retired and came back, he joined School of Law in Gujarat University, did his LLB, LLM, and then, not satisfied, went all the way to London to do his second LLM. Came back, the quest for knowledge didn't let him rest, and he decided to enroll a PhD. He did PhD on the comparable laws on environment between India and Germany. For this, he went all the way to Germany and spent 6 months to understand the local laws, and came back, studied this, submitted his thesis, and got PhD at the age of 75, when most of us really decide to take rest and play with our grandchildren. And when the last we met, he was thinking of doing another PhD in social law. This is environment, but we should talk about human beings. So let us talk about social law and how they operate and how oppressed communities get justice in this country. But somehow it was not to happen. But he had tremendous love for law. Probably it ran in his genes. He was third son of Justice Hirway, who was the High Court Justice in Madhya Pradesh. So he kept on writing, though not a professional practitioner, but he kept on writing and publishing in a lot of good journals subsequently. And this is what I thought is the most appropriate way to remember him and commemorate his memory, by creating a kind of situation where we invite very illustrious people to speak on legal issues. And that is what we are here today to commemorate his memory. And we have none other but Honorable Mr. Justice Madan Lokur. All of us have seen him on television with lots of awe and admiration, or his photograph in newspapers several times. This is the first time we are meeting him beyond the myth. Honorable Mr. Justice Madan Lokur is an eminent Indian jurist, a graduate in history from prestigious St. Stephen's College, Delhi University, with honors. He obtained his degree on law from the same university. He joined the Delhi High Court as an additional judge, was soon appointed as permanent judge of that High Court in 1999. He was then elevated as acting Chief Justice of Delhi High Court. Well, very interesting coincidence I would like to share with you. Justice Patel, who is presiding today, and Justice Lokur, they worked together in Delhi High Court, where Justice Patel was Chief Justice and Justice Lokur was working in the same court. So it is such a beautiful coincidence that we have two persons stolen from Delhi High Court formerly. Then he was subsequently appointed as Chief Justice of Guwahati High Court and then Andhra High Court during 11 and 12. He was elevated as Judge of the Supreme Court of India in 2012, where he continued with his position and retired as the senior most judge of Supreme Court in December 2008. He is now a judge in a non-resident panel of Supreme Court of Fiji, by far the first Indian judge to become a judge of a foreign country. Justice Lokur is well known for his commitment to justice and concern for democratic values. His notable judgments include the cases related to minority subquota in Andhra Pradesh High Court, where the divisional bench consisting of Chief Justice Madan Lokur and Justice P.V. Sanjay Kumar struck down the Government of India's decision to allocate 4.5% subquota for minorities. The bench held that the subquota was based on religion and not on any other intelligible considerations. The court criticized the decision by saying, in fact, we must express our anguish of the rather casual manner in which the entire issue has been taken up by the central government. Not many judges will have that kind of spine. Another major judgment is relating to a mining scam in which, as Chief Justice of Andhra Pradesh High Court, he suspended a special CBI judge and ordered his prosecution. Doesn't matter whether he was the same fraternity. Today he will be speaking on the 7 heavenly virtues. He is widely acknowledged as a thought leader on polity of India and minces no words in expressing his views. We are privileged to have you amongst us, sir. May I request Professor Indira Hirway to present a bouquet of flowers to him as a token of our respect. Flower. Now, I turn to another judicial luminary, Honorable Mr. Justice B.C. Patel, who very kindly accepted to preside over the memorial lecture. To this audience, he hardly needs any introduction. He is from this place, from this High Court, from amongst us. So he is one of us, but we are very grateful to you, sir, for accepting our invitation and come to preside over this function. To this audience, Honorable Mr. Justice B.C. Patel is well known. Justice from Gujarat, who rose to head 2 high courts, with high courts of Jammu, Kashmir and Delhi, besides his active decade in Gujarat High Court as a judge from 1990 to 2002. After attaining a master's degree in economics and political science from Gujarat University, Ahmedabad, he obtained his degree in law and enrolled as advocate in 1968. He started his practice in the city civil high court, civil court, and soon shifted to the High Court in 1970, where he joined his chamber of well-known criminal side senior advocate, late Mr. H.K. Thakur, where he worked on several important criminal cases and appeals. Subsequently, he practiced in civil, constitutional and criminal matters and also represented Gujarat LSD Board for 10 years in various courts. As he was keenly interested in education, he also taught as professor of law in different colleges for 15 years. In 1990, he was elevated to the bench of Gujarat High Court as permanent judge. And as a judge, he delivered several landmark judgments, particularly on town planning and building activities in urban areas. His celebrated judgments paved the way for the removal of encroachments in public places and the installation of safety devices in high-rise buildings. These judgments were widely appreciated by general public. He was elevated to the coveted position of Chief Justice of High Court of Jammu and Kashmir in 2002. Later, he was placed as Chief Justice of Delhi, where both of them were together, where besides civil, criminal and revenue matters, he keenly addressed public interest litigations in the form of writ petitions. Subsequently, Justice Patel was appointed as a member of the National Human Rights Commission. With his rich experience, he has contributed significantly to the legal scenario of the country. We are grateful to you, sir, for very kindly accepting our request to preside over this function. We are honored, sir. May I request Professor Indira Hirway to present a bouquet of flowers to him as a token of our respect. On the dais, Professor Indira Hirway is there. She is founder and former professor and director of the Center for Development Alternatives. and has nurtured the organization along with Dr. Ashok Hirway to become a globally acknowledged center for research on issues concerning humanity, particularly rural development, poverty, employment, gender issues. The center, better known as CFDA, is front-ranking organization in the field of social and economic research, has collaborated with large number of bilateral and multilateral agencies like ILO, UNDP, the World Bank, besides advising and evaluating the performance of various state governments and the central governments. We have done over 100 major projects, brought out about 8 to 10 books, and presented and published over 200 papers in national and international conferences and journals of repute. Under her leadership, Indira Ben has steered this organization thus far. The other person on the dais is Sri Rajendra Joshi, a board member of CFDA and executive trustee of SATH, an organization deeply committed to elevating the lives of slum dwellers in Gujarat and elsewhere by their capacity building and skill development, organizing micro credit and providing them counseling support to run their nano businesses. With these words, I again welcome all of you to this memorial lecture that we are eagerly looking forward to listen to. I request the President of today, Honorable Justice B.C. Patel, to conduct the proceedings. Thank you, sir. Thank you very much.
Chief Justice Patel, Professor Indira Hirway, Professor Dinesh Awasthi, Mr. Rajendra Joshi, and all the distinguished guests who are present here today. I would like to commence my lecture by thanking Professor Hirway for giving me this opportunity to express a few thoughts on issues pertaining to constitutional morality, the Constitution of India itself, the rule of law, and the times, the times that we are living in. I wanted to say a few words about Dr. Ashok Hirway, but Professor Dinesh Awasthi has already said all that there is to say. But I must say that I'm extremely impressed by the fact that at the age of 75, he got his PhD on issues pertaining to environmental law and a comparative study of environmental law between India and Germany. So really, he has left behind, in my view, a significant legacy. Apart from his academic pursuits, he's left behind a significant legacy as the founder member and advisor for the Center for Development Alternatives, which is hosting today's program. It is, I think, a continuing effort which must be commended. As a part of my lecture, I would just like to give a brief background. Sometime in 600 Christian era, 600 AD as we also call it, Pope Gregory I compiled a list of 7 deadly sins which had been discussed for the last 200 years. But also he compiled a list of 7 heavenly virtues to counteract those 7 deadly sins. And I would like to speak about those 7 deadly sins, 7 deadly virtues, and have tried to frame my lecture today around the Constitution, constitutional morality, ethics, and the rule of law, and of course the times that we are living in. But before I do that, I would like to make it very clear at the outset that I believe the governments of the day at all levels have achieved a lot and done extremely well for the people of our country, regardless of the political party at the helm of affairs. However, it is my view that to some extent we are sidestepping these heavenly virtues with the result that we are still facing great challenges today, which, though surmountable, are not adequately addressed. The intention of my talk is to highlight these problems so that they can be addressed at some point of time. We cannot only and always continue to praise ourselves. We must appreciate some of our shortcomings as well. I would like to preface my talk with the words of Dr. Ambedkar and Dr. Rajendra Prasad in the Constituent Assembly. Dr. Ambedkar spoke of constitutional morality during the debates and discussions in the Constituent Assembly. Essentially, he intended to convey that the Constitution is not like a standard operating procedure and cannot provide for everything. There will be gaps which in the legal fraternity we refer to as silences, but a heavy burden is cast upon the shoulders of our leaders to work the Constitution in the manner expected by the Constituent Assembly. Dr. Rajendra Prasad affirmed that if our leaders are men of character and integrity, even a badly drafted Constitution can be made to work. I would like to quote both Dr. Ambedkar and Dr. Rajendra Prasad when they spoke in the Constituent Assembly. Dr. Ambedkar said on 25th November 1949, and this is very important, he said, "I shall not therefore enter into the merits of the Constitution because I feel, however good a Constitution may be, it is sure to turn out bad because those who are called to work it happen to be a bad lot. However bad a Constitution may be, it may turn out to be good if those who are called to work it happen to be a good lot. The working of a Constitution does not depend wholly upon the nature of the Constitution. The Constitution can provide only the organs of state, such as the legislature, the executive, and the judiciary. The factors on which the working of these organs of the state depend are the people and the political parties they will set up as their instruments to carry out their wishes and their politics." Dr. Rajendra Prasad said on 26th November 1949, "Whatever the Constitution may or may not provide, the welfare of the country will depend upon the way in which the country is administered. That will depend upon the men who administer it. It is a trite saying that a country can have only the government it deserves. If the people who are elected are capable and men of character and integrity, they would be able to make the best even of a defective constitution. If they are lacking in these, lacking in character and integrity, the constitution cannot help the country." So keeping in mind these sentiments expressed by these great men in the Constituent Assembly, I have chosen to speak about the 7 heavenly virtues, and I will be adverting to them during the course of my talk. The first heavenly virtue, and which is supposed to be the main heavenly virtue, is humility. And the question that I wish to ask is that do our constitutional authorities exhibit humility in their constitutional functioning and in their constitutional conduct? And is it in consonance with constitutional morality? That is the question which I think arises in our mind all the time. Now, we have in the recent past governors of several states not assenting to bills that have been passed by the state legislatures. It's a matter of common knowledge and a part of the Constitution that the function of a governor in this regard is either to grant assent to the bill that has been enacted by the state legislature, or to send it back for reconsideration if there is some doubt in the governor's mind, or if there is some constitutional issue that arises in the sense that it may be in conflict with a provision of the Constitution or a provision of some central law, then to refer the bill to the President for consideration. There is no fourth option that is available to the governor. But what we have been finding in the recent past is and this has happened in several states. It has happened in Kerala, it has happened in Tamil Nadu, it has happened in Chhattisgarh, it has happened in Punjab, it has happened, I think, in Jharkhand as well, where bills are enacted by the state legislature and no action is taken on them for several months, almost 2 years in some cases. It has happened in West Bengal also. Now, the matter was then taken up to the Supreme Court with the view that by the state governments themselves to ask the Supreme Court to lay down the law on the powers of the governor to not take any action on bills that have been enacted by the state legislature. And as luck would have it, when the matter came up for consideration before the Supreme Court, the governor of Kerala and the governor of Tamil Nadu, they acted upon the pending bills and either returned them. The governor of Tamil Nadu returned most of the bills to the state legislature and sent one or two of them to the president for consideration. And more or less the same thing happened with the governor of Kerala. He also sent some bills to the president for consideration and withheld assent in respect of some bills. Now, what the governor of Tamil Nadu did was that he just sent the bills back to the state legislature without giving any reason. Now, constitutional authorities, when they are acting as constitutional functionaries, are supposed to act with reason. They're supposed to give reasons. After all, if the bill was held back for several months, why is it that it was sent back to the state legislature for reconsideration without giving any reason? If that had to be done, it could have been done on day one itself. Now, when the bills came back to the Tamil Nadu legislature, within a matter of 5 days, there was a special session and the bills were passed again. I believe they're still pending with the governor of Tamil Nadu. So, is this, a part of constitutional morality? Is this what was expected by the Constituent Assembly, which one of the speakers said at that point of time, that the governor of a state is in the nature of a cementing factor. The idea is not to create chaos or to interfere in functioning, but to be a cementing factor. Now, is this cementing factor? This is, I think, one of the questions that we have to look at. The Punjab governor also, in one instance, when the chief minister said that I would like to call a session of the state legislature, he refused. He said, no, I don't think the state legislature should be summoned. So the Punjab government went to the Supreme Court and said, how can the governor say that? As the chief minister, it is necessary to have a session of the state legislature. Why not? And the Supreme Court said that, well, you have no power to decline this request of the chief minister, of the government, of the cabinet, and you must call the session of the state legislature. So all these instances, are building up, and the governors who are constitutional authorities are being taken to court on these kind of issues. We've also had the governor of Kerala, withdrawing the pleasure of the governor and thereby telling the chief minister that this particular person is no longer a member of the cabinet. Again, there is no constitutional power to do that. Of course, it says, the Constitution says, during the pleasure of the governor, but that doesn't mean that the governor can say, I withdraw the pleasure at my will. The governor of Tamil Nadu went a step further and said that I'm dismissing this particular cabinet minister. Obviously, there was a big furor, and later in the day, the governor of Tamil Nadu withdrew the order dismissing a cabinet minister. Again, these are questions that arise. Where is the power? What about constitutional morality? What about provisions of the Constitution? What about ethics? These are questions that arise. Now, we've also had the governor of Kerala. I'm sorry, I keep referring to these two, Kerala and Tamil Nadu. But in Kerala, instead of reading the customary speech that is given on the opening day of the session, the governor spoke for 1 minute. That's all. Declined to read the speech. Tamil Nadu, the same thing happened. Not once, but twice. In 2023 and again in 2024. In fact, on one occasion, even before the national anthem could be sung, the Tamil Nadu governor left the assembly. Now, again, is this what one would expect from a constitutional authority of that stature and of that wisdom? Maharashtra governor also did something, equally strange, which is to say that the governor of the cabinet of Maharashtra, the government of Maharashtra, nominated or sought to nominate 12 persons to the legislative council. The governor did not act upon the recommendation, did not nominate these 12 persons. And the matter was kept pending for as long as about 8 months or so. Eventually, somebody went to the Bombay High Court and said that, the government has nominated 12 persons to the Legislative Council, but the governor is not acting upon the recommendation. Can the governor do that? The Bombay High Court gave an order saying that, well, when the cabinet has made a recommendation, you should accept it. I mean, unless there's a very good reason not to accept it, you just can't say that I will not act upon it. And an appropriate order was passed by the Bombay High Court, but the governor still did not appoint these persons until the Maharashtra government fell, and the new government then withdrew these nominations. So really the entire episode of nominations was, in a sense, scuttled by the governor. Again, issues of constitutional morality. The speaker, again, a very important constitutional functionary. There have been instances, one was in Manipur, where the anti-defection provisions were attracted, but the speaker did not take any decision on the petitions for disqualifying the MLAs. The matter went up to the Supreme Court, and the Supreme Court said that the Constitution does not prescribe a time limit. Obviously, as Dr. Ambedkar said, you can't have a standard operating procedure. But when there is no time limit prescribed, or when a reasonable period is prescribed, you have to do it within a reasonable period of time. And in this case, the Supreme Court said that, in our opinion, 3 months is a reasonable period of time, so you please take a decision within 3 months. The Speaker did not take a decision within 3 months. He took a decision a little later, but not within 3 months. A similar situation arose in Maharashtra, where again, the Speaker was told that you take a decision on the disqualification of the MLAs. Time was granted, the Speaker did not take a decision. Time was extended sometime in September 23 to 31st of December 23. The Speaker still did not decide, and then a little later he took a decision, and that decision is now under challenge in the Supreme Court. So you have the governor, you have the Speaker. Now, what about the Chief Minister? All right, another important constitutional functionary. There have been instances of a minister being in judicial custody for months together. The minister is not resigning, and the Chief Minister is not dismissing the minister from the cabinet. We've had this in West Bengal. I think only last week the minister resigned. We've had this in Delhi, where the minister has been in custody for several months. Ultimately, he resigned. And there is another third state where also the same thing happened. So we have these constitutional functionaries, who, in a sense, they are acting within the letter of the Constitution, or they're not acting outside the letter of the Constitution. But they are taking advantage of these so-called silences of the Constitution. And that is what, Dr. Rajendra Prasad and Dr. Ambedkar had referred to, that if you have this character and integrity and you have problems which arise, think about constitutional morality. Is this what the Constitution requires us to do? Or is this what the Constitution says that you should not do? That's the question that these constitutional functionaries are required to answer. Now, the second important heavenly virtue is that of charity. The question that I would like to ask is that does constitutional morality permit filling your own pocket as a part of charity? They say that charity begins at home, but it should not end over there. Now, we've had in the recent past the electoral bonds scheme, which has now been struck down by the Supreme Court as being unconstitutional. During the currency of the electoral bonds scheme, what is it that has happened? They say that something like 10,000 crores of electoral bonds have been purchased. Where has the money gone? The money has gone to the persons who made the scheme or to the political parties that made the scheme. So more than 50%, about 55% of the 10,000 crores has gone to a particular political party. In the states, there are some other political parties which are at the helm of affairs. They have also benefited. So this charity, which is a heavenly virtue, which is meant for people to give, has been converted through the electoral bonds into a charity for the political party itself. The scheme is completely opaque. Who has given the amount, how much has been given to which political party is not known. And that is one of the reasons why the Supreme Court struck it down, because they said that as a voter, we are entitled to know what is happening. We have a right to know, which is a constitutional right, and that right is being taken away. Please remember that free and fair elections are a part of the basic structure of our Constitution. There is no doubt about it, and the Supreme Court has said that in unequivocal terms. Now, with this electoral bonds scheme and with this huge amount of money that is coming in, 10,000 crores and perhaps a little more, where is the level playing field? And then if the level playing field is not there, does it vitiate the electoral process? That's a matter of concern. And that is the reason why the Supreme Court said that the opacity in the electoral bond scheme must be struck down. There is also a possibility that there could be some sort of a quid pro quo, that some big corporate houses give a huge donation intended for a particular political party, either in the state or at the center, and there is a quid pro quo. How does one know that? You don't know that because you don't even know whether that corporate house has given an electoral bond and transferred some funds to a political party or not. So directions have been given by the Supreme Court to disclose all this information. Time has been given to sometime in mid-March. Let's see if the information eventually comes out. Another aspect of charity, in fact this is really the reverse, is the Mahatma Gandhi National Rural Employment Guarantee Scheme, NREGA. Now this is a demand-driven scheme for the unemployed in the rural areas. They are willing to work, they want to work so that they can earn a little bit. And under the scheme, a minimum of 100 days can be offered. That has not been achieved. But again, you have instances, a large number of instances where persons are doing work under NREGA and they're not being paid their wages in time. I remember dealing with this case in the Supreme Court, and we received complaints that the wages are not being paid in time. They're supposed to be paid within 15 days. And after 15 days, if the amount is not paid, the workers are entitled to interest. But it became so frustrating for them, or the persons who were representing these workers from across the country, they said, forget about the interest, at least give us the money for the work that we have done. Now that in some form or the other is being withheld, either because funds are not being released in time, so wages which were due last year are being budgeted this year, and it's a sort of a carry forward of the wages. I don't know about the interest, whether the interest is being paid or not, but there are other problems that are also coming up in this scheme, which is now being converted into some sort of a charity. From a right, it is being a statutory right, it is being converted into a charity. So you have problems of biometrics, where the job card does not match either with the Aadhaar or with the bank account, or there is some other problem. In 22-23 and maybe a little later, something like 7 crore job cards were cancelled, which means that 7 crore persons who were registered as unemployed labor in rural areas were not able to get employment and not even earn that, whatever little amount is paid to them towards their wages. So in a sense, this right has been converted into a charity, that we are doing it so that you get some money, not that you have a right to get employment. Because we are not able to provide employment, we are asking you to do some work, we'll pay you for it, but it is being converted into charity. So again, one heavenly virtue, that of charity, is being destroyed in a sense. The third heavenly virtue is chastity. Now, I don't use it in the word in the sense that was used by Pope Gregory, but I use it in the view of purity in thought and purity in deeds. So your thoughts have to be pure, your deeds have to be pure, and that is how I look at chastity. Now, the question again is, what is the role of constitutional morality in our electoral process? How pure is it? As I mentioned earlier, free and fair elections are a part of the basic structure of our Constitution. This was said by the Supreme Court many years ago when the election of Mrs. Indira Gandhi was under challenge. The Constitution was amended and the Supreme Court said you cannot amend the Constitution and take out free and fair elections. The Constituent Assembly debated the Election Commission of India. And the view was that there should be no executive interference with the electoral process and with the Election Commission. There were some views expressed, there were some doubts expressed, but perhaps because of shortage of time, they were not able to arrive at a consensus on how to frame the law with regard to the Election Commission. But the view was that there should be no executive interference. Subsequently, we know that the executive was appointing the Chief Election Commissioner and was also appointing the election commissioners, and that continued right from 1950 onwards until recently. We had 2 commissions. One was the Dinesh Goswami Commission Committee in 1990, which said that there should be a collegium for the appointment of or the selection of the election commissioners and the chief election commissioner. Then we had the Law Commission of India, 255th report of the Law Commission of India, which also advocated a collegium. Interestingly, it was suggested that the Chief Justice of India, as an independent person, should be a member of that collegium. When the matter came up before the Supreme Court said, well, the Constitution says that a law has to be enacted, a law has not been enacted, and the circumstances were, like I had mentioned, perhaps shortage of time with the Constituent Assembly. So the Supreme Court said, that a collegium should be established for the selection of the election commissioners, and the Chief Justice of India should be a member of that selection body. Parliament passed a law soon after, and they replaced the Chief Justice of India with a cabinet minister. So the intention of the Constituent Assembly was to keep the executive out of the selection process. But now the law has just completely reversed that. And the political executive, the Prime Minister, of course, is the chairperson of the selection committee with a cabinet minister. The political executive is now in control of the appointment of the election commissioner. And what is strange, a little strange, that there is a committee to shortlist persons. They can recommend 5 persons, that we are shortlisting 5 persons for selection as the election commissioner. But the selection committee, this collegium, can go beyond those 5 persons and say that, you know, we are appointing a 6th person as a member of the election commission. So the entire debate and discussion that took place in the Constituent Assembly has been completely sidestepped. Again, the issue is of constitutional morality. So, this is the position with regard to the election commission. Now, when we talk about free and fair elections, all right, we do elect our representatives, but a new expression has come into the political lexicon, which is resort politics. So we elect our MLA, we elect our MP. Fortunately, it has not happened in Parliament as yet, but we elect our MLA to represent us. What happens? In a crunch situation, the MLA defects. And if there's a defection, as I had mentioned, sometimes the speaker doesn't act. But a way has been got around to get over the 10th schedule of the Constitution, which deals with the anti-defection law, which is the anti-defection law. And we have resort politics where MLAs are shifted from one place to another place so that they are not horse traded. That's the expression used by the Supreme Court, that horse trading goes on, which is, I think, a somewhat pejorative expression, but anyway, that's been used by the Supreme Court. We've had that situation in Karnataka some time back. We've had